Hi, I'm Anna Denton-Jones from Refreshing Law, and in this second video on the Employment Bill, I'm going to be talking about the position as regards collective redundancy consultation. So large scale, as I'm sure you're all aware, if more than 20 people are at risk of redundancy within a 90-day period, then there's an obligation to consult with employee representatives of those employees, and that's either trade union or specifically elected representatives for the purpose of the exercise. Now, that comes from Section 188 of the Trade Union and Labour Relations Consolidation Act from 1992. And the particular phrase that's used in that is that we're looking at the numbers of redundancies in one establishment. And that phrase, one establishment, actually comes from a European approach in a directive that used to apply to us, but no longer does because of Brexit. You might remember when Woolworths went out of business that there was a question at the time about whether or not consultation needed to happen on a per store basis. So how many employees are being made redundant in this particular store, or whether it could be looked at as a wider question. And the answer that we now know from that litigation was that one establishment meant one store. So if you happened to work in a Woolworths that only had 15 people, you were not subject to collective consultation rules. In the new employment bill, bear in mind that it was announced in draft format in October 2024. It's still going to go through Parliament and potentially get some tweaks along the way. And then the law that is created by that new bill will have different dates as to when it comes into force. We're told that it's unlikely to be before 2026, so 2 years lead in to when this is likely to happen, that it comes into force. So no immediate panic to do anything, but the change in clause 23 of that bill, I think, is really going to affect how organisations work. So if you think about redundancies, sometimes they can happen in a sort of cascade situation where you might have some jobs being affected in one particular region. There might then be a merging of two offices perhaps going on somewhere else in the country. That may create some redundancies. So we've already got two pockets of redundancies. And then there might be what we would have otherwise thought was a low number of redundancies, something small scale, somewhere else. Maybe we're getting rid of some administrative staff somewhere else. And all of a sudden, we've got these little pockets of redundancies. But if you add them all together, you can get to 20 and you can start triggering the collective obligations. And we know from case law that whilst when you start with perhaps the first pocket, you're not obligated to collectively consult unless we know about the other things that are happening within a 90-day period. If the closer we get to the second pocket, the third pocket, the fourth pocket, we start to realise that actually we are going to trigger it, then we are expected to collectively consult with those who remain in employment with us at that point. And when I talk about across the organisation, I'm not just talking about your organisation. If your organisation is associated, So maybe it's a subsidiary of a group of companies, or maybe it's the parent company where there are subsidiaries, or there are sort of two sister organisations. An organisation needs to be looking across the whole patch to decide whether or not it's hit the 20. So the bigger you are, the more complex the structure, the more likely you are at any one time to be hitting the 20 collective consultation, because there's just stuff going on all the time, all over the place. So it could really change the way in which redundancies are handled in the UK. Obviously, from a Labour government perspective, they're very much in favour of employee representatives being involved and having their say. And of course, it's good practice to do that. So it may be that we need to have elected representatives, some sort of redundancy committee, who have had some training. I certainly get asked from time to time to go in to do a half day with elected representatives. So they understand what the role is and what they can achieve in that role, and what to do when they are asked to act as representatives. So maybe we need more of those bodies ready and waiting so that we can bring them into the fold when we do hit that 20 employees being proposed as redundant in a 90-day period. The next video I'm going to do is on the day one rights for unfair dismissal, so the removal of the 2-year period. If you've got any questions, it's adenton@refreshinglawltd.co.uk.